I'm Menno Kaminga, a professor of international law. It's my pleasure to introduce Liesbeth Lijnzaad, who is an old hand at the faculty. She defended her PhD dissertation here many years ago, but now she's the legal advisor of the Dutch Foreign Ministry, and in that capacity she represents the Dutch state at international courts and tribunals, including the case at the Law of the Sea Tribunal. But she's also a part-time professor here at the law faculty, and so she can switch heads, I would suggest, tonight. And we look forward to a very interesting presentation.
Thank you. Thank you. Good evening, everybody. Now, I'm going to talk a little bit about the Arctic Sunrise case before the International Tribunal for the Law of the Sea. And I'm completely partial because I'm the agent representing the Netherlands, so if you think I'm partial, we can discuss that after I've told you about the case, and maybe we can have a discussion later on. Now, to begin with, what am I going to speak about? I'm going to speak briefly about the events that led to the case. I'm going to speak about the procedure before the Law of the Sea Tribunal, otherwise known as ITLOS. I want to make some comments on the practical aspects of dealing with a case like this. And I would like to make it absolutely clear, I'm not going to talk about the individual people, the Artic 30 as they are called these days, 30 people with 18 different nationalities who used to be in pretrial detention in Murmansk, then were transported to Petersburg and are now, I think, out on bail in Petersburg. And also, quite crucially, I'd like to make the point that the Netherlands is not Greenpeace. That's a very, very important aspect for us, for us, at least for the state. We are not representing Greenpeace. We are not in any way expressing support for what they're saying, nor are we saying that we disagree. We just don't say anything about it. We are acting in our own right because the Arctic Sunrise is a ship in a Dutch registry, so it has nationality of the Kingdom of the Netherlands, hence the involvement of the administration of the Netherlands. In case you would like to study everything that has been exchanged, all the paperwork that the Netherlands has produced, all the text that the tribunal has produced, go to www.itlos. I made a mistake. Of course, it's dot. It's not a slash. And look for case 22, and there you can find everything. But before that, and this is really daunting, I am going to try and get the YouTube movie to work. This is what it looks like, what the events on the events on the Arctic Sunrise looked like. Probably should turn the sound up. This, I understand, is a movie of the boarding of the Arctic Sunrise. Just to have an idea, this was Okay, we'll leave it at that. That was only to give you an impression. It's also an impression of my lack of talent in getting these things in a PowerPoint presentation. Anyway, you can imagine it looked very daunting for people on board of the Arctic Sunrise. The Russian Coast Guard boarded the ship, and it didn't really seem very friendly. So what exactly happened? Now, the story starts somewhere in September, maybe even in August of this year, when Greenpeace is taking action near Provisional. That's the name of the installation. It is the Save the Arctic campaign, which I understand is aimed at protecting the pristine environment of the Arctic and the prevention of oil leaks, gas leaks, pollution of all kinds. So they are in that region protesting and doing what Greenpeace normally does. Now, on the 18th of September, the Russian Federation informs the Netherlands of its decision to seize the Arctic Sunrise. There had not been any forewarning. The first thing we hear about it is the decision to seize the Arctic Sunrise. This comes as quite a surprise in The Hague. We had not, as I said, not been warned, and normally you would get some sort of announcement. If this or that doesn't happen, we will seize, but this time it was, we have decided to seize the Arctic Sunrise, and on the 19th of September, the Russian Federation takes control of the Arctic Sunrise in the Russian exclusive economic zone. Exclusive economic zone is to a maximum of 200 miles out of the coast, and it is our understanding that there is a certain amount of jurisdiction for the coastal state in the exclusive economic zone, but certainly not the jurisdiction to, or the authority to just board a ship under the flag of a third state. So we are very upset by the fact that the Russian Federation takes control of the Arctic Sunrise without the consent of the Netherlands, and we believe that as a matter of law we should have been asked to give consent, and if we had not given consent, such boarding would not be legitimate. Now, the fact that it hasn't even been asked, we think is absolutely contrary to the law. Russian Federation then detains the vessel and the crew, and in the end, you know the story, everybody will end up in Murmansk, and the crew or everybody on the ship will end up in pre-trial detention. After the 19th of September, there are attempts to talk to each other in the sense of, well, Mr. Ambassador, could we get together and talk about these issues, because we think that our rights have been violated, but at the same time we are open to finding an amicable solution. There are a number of diplomatic notes exchanged between the Netherlands and the Russian Federation, but nothing much happens other than that. We get news reports from Murmansk that everybody is locked up there. Now, the Provisional installation, it's a drilling platform. We understand that it is being built to withstand all kinds of weather. It is ice-proof. It's built for the harsh environment in the Arctic Sea, and it is standing in the Russian exclusive economic zones. As things go, a safety zone has been established around the installation, and this is on the basis of a rule in the Law of the Sea Convention. It's all in Article 60. If installations, oil platforms, oil rigs are built, the coastal state has the authority to establish a safety zone around the installation. But the convention gives you limits for doing that. It may not be wider than 500 meters, and it must be well advertised, and it is possible to provide rules for the enforcement of that safety zone. Now, there is a slight problem with Provisional. The zone is much too large. It has been properly advertised, but it is 3 miles wide, and that is quite a lot larger than the 500 meters around the platform that is acceptable. The rule in the Law of the Sea Convention is also that all ships must respect safety zones. You may organize enforcement, but at the same time, it is a moot point what exactly it is that you may do by way of enforcement. Presumably, you may chase ships that are in the safety zone, so just make sure that they leave the safety zone. It is also beyond contention that an administrative fine is possible. But apart from our problem with the boarding of the ship, we are thinking that arresting the ship, towing it all the way to Murmansk, and arresting the crew is really doubtful. It's really doubtful whether that is acceptable in terms of proportionality. Is there a legal basis for such enforcement action? So that's Priras Lomnaya, but I would say that we have stated over and over again that the Netherlands and the Russian Federation have similar sentiments with respect to the need to properly protect oil rigs. Think of collisions between ships and oil rigs. Those are absolutely to be prevented. I mean, that there is absolute logic in having such safety zones, but then they ought to not be bigger than the convention allows for. Right. So as I said, there is an exchange of diplomatic correspondence, diplomatic notes. The ministers speak to each other on a number of occasions, but nothing much is moving, which then leads us to think, well, what else can we do? Because you must understand, the minister is under some pressure with respect to the whole event. And as the saying goes, foreign politics is to a large extent domestic politics, and in the Netherlands, in Dutch politics, there is a keen interest in what is it that the minister is going to do about this unlawful boarding and arrest of the ship and the position of the crew of the ship. So the first thought we have is that we might be able to use the prompt release procedure. Sorry, I have a cold. Now, the prompt release procedure is quite an unusual procedure in the Law of the Sea Convention, where when a ship is arrested and a bond for the release, a reasonable bond for the release of that ship has been offered, within 10 days of the detention, on the posting of the reasonable bond, the ship should be able to leave. This is the procedure of prompt release. So we're looking into that, and we're thinking, well, this might be a possibility, but then it is only a possibility when the reason for arresting the ship is either an infraction of fisheries legislation, so-called IUU fishing, illegal and unregulated fishing, or the risk of marine pollution. So if either fisheries or marine pollution have been the reasons to arrest the ship, that would give the possibility of the state, the national state of the ship, offering the posting of a reasonable bond. Then the ship should have to go. And if that doesn't work, if the ship is not allowed to leave, there is a procedure to be followed called the prompt release procedure, which also takes you to the tribunal in Hamburg. However, even if initially we had the impression that marine pollution was a concern to the Russian Federation, they inform us in a next diplomatic note that they are more concerned with piracy and the crime of hooliganism, which then takes the grounds away from moving towards prompt release. So what next? No prompt release then, and you will see the Netherlands initiating an arbitration. Mind you, on our side we are looking at finding a procedure short of negotiations, we keep repeating to our colleagues on the other side that we are welcoming any step towards negotiations, towards discussions, but at the same time there is much pressure on the whole affair, so we keep looking for other possibilities of solving this through the mechanisms of peaceful settlement of disputes. So on the 4th of October, we bring an arbitration against the Russian Federation under Annex 7 of the Law of the Sea Convention. And I can tell you, doing that is in fact a very nice and cozy affair. I got on my bike, cycled to the Russian embassy, drank some tea with the Russian ambassador and told him, we are starting an arbitration and this is the paper. And the same day, the Netherlands ambassador in Russia delivered the same paper to the authorities in Moscow. So we had a good chat. We spoke about, did we already have very clear ideas about procedure, about the location for arbitration? We did not. So after half an hour, I leave again and I have started an arbitration. It was a sunny day in The Hague. Interesting was one demonstrator from Greenpeace standing in front of the embassy, and that was it. Now, so starting an arbitration, it sounds daunting, but it wasn't really. But the reason for doing this is that starting an arbitration gives you access to another procedure, which is the procedure that we really wanted to use, which is the request for provisional measures. Now, the request for provisional measures is again a procedure before the Law of the Sea Tribunal. It's one of those urgent procedures, very much like a kort geding in the Netherlands, where you say that you have elements of a more complex legal problem, but those elements need to be solved as soon as possible. So you're not bringing the whole issue of what happened to the Arctic sunrise and the whole issue of the size of the safety zone and of the arrest and all of that. That is part of the arbitration. But then the convention gives you the possibility to bring the more urgent elements in your problem before the Law of the Sea Tribunal in Hamburg under a request for provisional measures. The convention tells you you have to have started your arbitration, and then 2 weeks later you can go to the tribunal and ask for provisional measures. What this does is that you have to work very hard because you have to prepare a proper paper to start the arbitration. It has to have all your concerns, all your legal issues, the whole scope of it. And then once you've done that, you continue straight away with writing court papers to be brought in Hamburg on the urgent issues. So on the 21st of October, we submitted the request for provisional measures. This time I went to Hamburg and handed it to the registrar at the tribunal and then had a discussion with the president of the tribunal. And the next day, 22nd of October, we get a note verbale. NV stands for note verbale. That's a diplomatic correspondence from Russia in which they say that they will not participate in the arbitration and they don't intend to appear in the proceedings on provisional measures. That is very strange, in the sense that for us, the whole decision to take Russia to court, you will understand that's not a decision taken lightly. The Netherlands is continuously saying we want to talk to our opponents, we want to see whether we can have discussions, we want to solve this amicably, but then at a certain point we decide to go to court to Russia in the eye of everyone. It was very visible that we did that. So you have to be very convinced, you have to have properly weighed your chances, including the risks that you may fail when you go to court. So we have gone through this process of getting there and of have taken the deliberate choice to go to court. And the very next day we hear that our opponents don't intend to appear. That's very strange. So it means that in our court papers, the third round of papers we're preparing, we need to prepare our statements in court. We also need to include how the court will need to address the fact that the other side hasn't shown up. And then on the 6th of November, we go to Hamburg for the hearing at ITLOS. Again, very unusual. We're sitting on one table where it says Kingdom of the Netherlands, and on the other side of the room, there's a table where it says Russian Federation, and nobody's sitting there. The journalists all make photographs of the Russian Federation at an empty table. They find this apparently very interesting. And then on the 22nd of November, there's a decision by ITLOS. Now, I've put the dates on the slide. It demonstrates to you that the Provisional Measures procedure gives you a reply by the tribunal within a month. So it is really an urgent procedure. It is everything. I understand they stopped their ordinary work. They are still working on case 19, and I think soon on case 21. But they stop all their ordinary work, and within a month they give us a decision on the claim that we have brought forward. Now, what you need to do to be able to request provisional measures under Article 290 of the Convention. The text says that this is an urgent procedure pending the constitution of the arbitral tribunal. Now, setting up an arbitral tribunal takes time. We initiated the procedure, so because while we start, we have time to think about who should be our arbitrator. Arbitration, as you may know, it is a legal way of settling disputes, but it is in a way less formal, and at any rate it is more confidential than going to court. One of the important aspects, certainly important for states, is that it is the states themselves who constitute the arbitral tribunal. We appoint an arbitrator, our opponents appoint an arbitrator, and hopefully the two of them are able to appoint the three other arbitrators. So we have already thought about this, but it takes some time to set up the arbitral tribunal. You need to look into the rules of the arbitral tribunal. You need to look into very mundane things like who is getting paid what. You need to look into where is the arbitration going to take place. So it does take place. It does take a long time for the tribunal to be ready. So pending the constitution of the arbitral tribunal, you can request for provisional measures. Okay, that's one thing. The other thing that the law requires is that you have to demonstrate before the tribunal that there will be prima facie jurisdiction of the arbitral tribunal. The Tribunal for the Law of the Sea is not going to decide on the bigger problem, because that is for the arbitral tribunal. But you rely on the bigger problem to bring your urgent case for the provisional measures. So it is important that the Law of the Sea Tribunal at least investigates whether at face value you have a claim. They're not going to decide the claim, but they need to investigate whether you have a serious claim. Because the other side, of course, needs to be protected against fancy lawsuits, something like that. The interesting thing is that the mandate of the Law of the Sea Tribunal is rather broad. They may prescribe any provisional measures aimed at preserving the rights of those who bring a claim, and presumably also the other side. So any provisional measures means that they have fairly large liberty at deciding what it is that they're going to give, what their order will be. Now, of course, I already mentioned this is about an urgent case, and it is an interim decision. So it may be that the tribunal, the arbitral tribunal in the end, takes a decision that's different from the provisional measures. The provisional measures will last as long as the arbitral tribunal is busy deciding. And one element in their decision could be, well, the decision by the Law of the Sea Tribunal, looking back, was not the right decision. So there is a time limit to all of this. Now, all of this translates in the following structure for the arguments that we have made. We had to say something about the consequences of the non-participation of Russia. It's not just, hey, they're not there. You have to provide some thinking for the Law of the Sea Tribunal as to what the consequences of that would be. Then, of course, we have to prove that the Law of the Sea Tribunal has competence over the question that we are bringing before them, and that they have the competence to determine provisional measures. And a part of that, as I just said, is the fact that we have to demonstrate that there is prima facie competence of the arbitral tribunal, irrespective of the future decision of that arbitral tribunal. We need to demonstrate that our claim is supported by facts, so quite some time is spent on what I've only dealt with rather briefly. What happened when, where was the ship, when was the ship boarded, who was detained, where did all of this happen? Factual statements. There it turns out that it is quite difficult when you are the flag state to provide all those facts, because it all happens far away. Those who are in the know about these facts are the Russian Coast Guard, because they are there. At the same time, you don't necessarily want to rely on what the other side is saying, so that raises the interesting question as to, well, how do we know exactly what happened? Of course, there is little YouTube movies like that, but it doesn't tell you where it was. It doesn't even tell us whether these people coming down from the helicopter, whether they were actually from the Coast Guard. To my surprise, because I thought this was very logical, nobody seems to have written down the registration marks of the helicopter. If you would have known that, you could have just Googled and it would have said, Russian Coast Guard helicopter or something. So there is an issue there about how do you demonstrate these facts. At the same time, as I said earlier on, the Netherlands is not the same as Greenpeace. Greenpeace, no, although apparently some of the information had gone missing in the whole process. So what it meant was that we have been looking at the resume of facts with Greenpeace and tried to take out anything that was more of a political observation. And of course, political observations are fine by NGOs, but not if the Netherlands wants to submit them. Then the other requirement is that the claim is supported by law. So the claim can be substantiated, and that means that you have to demonstrate that there are substantive rules of the law of the sea that have been violated. Well, things like the issue about the size of the safety zone, the issue about in the EEZ, you have to ask for permission from the Netherlands to board a ship under the flag of the Netherlands, things like that. So all of that then leads to the notion that, in our view, the requirements for the ordering of provisional measures are met, and final submission, that's more of a technicality when the agent has to reiterate all the positions, because you have to, I was surprised by that, I'd never seen that before, you have to write down all your final submissions and sign it and hand it over to the registrar at the end of the oral proceeding. Right, now, as to the Russian non-appearance. So we get this note verbal. In fact, we don't get it, but they send it to the registrar of the Law of the Sea Tribunal. And they're not going to participate, not in the arbitration, nor in Hamburg. Now, we did some research, and mind you, this whole exercise, in fact, is a huge learning experience in terms of reading what judges have said in all kinds of case law. So our take on this was that Of course, nobody can oblige a state to appear before court. States are sovereign, and if they don't want to show up, they don't show up. It's as simple as that. However, over the years, our calculations were that gradually, as the approach of states has shifted from I don't like this court case, so I will not appear, to I don't like this court case, and I'm going to tell the judge. So that's a different thing. So rather than not appearing, particularly the past 25, 30 years, states have chosen to appear and then make a lot of noise about the fact that the court would just not have jurisdiction, and that was completely unfair. We said this to the court, irrespective of the fact that, of course, we cannot make Russia appear. We've expressed our regret. A court case is not only much more interesting, but perhaps people are challenged much more when you know that your opponent is also doing their work very well, so you have to be on your toes. And it is a quite strange experience to be there, and my learned opponent, I can't speak for my learned opponent, but it would be so nice if they would have been here. Anyway, so we made the point that our understanding is that practice has drifted to states appearing to say that there was no jurisdiction rather than staying at home. Now, there was another issue there, which is it was a default case, but the Law of the Sea Tribunal had never ever dealt with a default case before. The tribunal exists, I think, 16 years or something like that. It's not very busy. This is the 22nd case in 16 years, so it's not very heavily used. But so far, in every case, the other side had appeared. So we felt that we had to suggest to them, what do you do with a default case? Now, the statute of the court gives some answers as to the issues that need to be clarified, and they would be things like the other side has been properly informed, they have been kept aware of everything that's happening in the court case. So we kept sending notes to the court on different issues, and then we got replies from the registrar saying, your note, by the way, your note has been communicated to the authorities of the Russian Federation. And this element of the claim is substantiated in law and in fact is another element which the court will have to address when looking at the default aspect. So what we did was we provided the court, we noticed that Article 28 of the statute of the Law of the Sea Tribunal is quite similar to a provision on default in the statute of the International Court of Justice. In the text is slight differences, but it has the same components. So we thought what we are going to do is we're going to refer to relevant case law from the International Court of Justice. Most important, the ICJ Nicaragua case, Nicaragua versus the United States, where the United States did appear in the initial phase, but then stayed home for the substantive phase. And we provided the court with a number of quotes from relevant case law to help them along in looking at this issue of default. Now, we were very happy, I would say, with what the tribunal said. They said the non-appearing state is nevertheless a party to the proceedings. This they said after having established that Russia was fully aware of the fact that the case had been brought, so that they were properly informed. And they also said that the Netherlands should not be put at a disadvantage because of the non-appearance of the Russian Federation. So we were quite happy with the conclusions that they drew, and I would say that this is certainly an element of case law on which they will build in a future default case. Now then, as to jurisdiction of the Law of the Sea Tribunal, the Law of the Sea Convention gives you 4 choices with respect to jurisdiction in situations of the settlement of dispute. You may choose between expressing your preference for the International Tribunal for the Law of the Sea. You may choose the International Court of Justice. You may choose arbitration, or you may choose special arbitration. These 4 forms are all described in the Law of the Sea Convention. and many of them are described in an annex. Of course, not the International Court of Justice, because that has its own statute. What happened was that the Russian Federation had said, we prefer arbitration for every type of dispute settlement. The Netherlands had said, after all, we are the host state of the International Court of Justice, that we would choose the International Court of Justice for dispute settlement. So neither the Russian Federation nor the Netherlands had chosen the Law of the Sea Tribunal, which is, of course, why we ended up with the Law of the Sea Tribunal. It's interesting how these procedures work. The conclusion, and this is one of the good things in the Law of the Sea Convention, is there is a default rule if two parties in a conflict have chosen different means of settling their disputes. The default rule is you go to arbitration. So there is always a mechanism. This is, of course, leaving aside the whole debate about defaulting in a procedure. Then there was another obstacle. And in its note on the fact that it would not appear, the Russian Federation also referred to its reservation that they had made at the ratification of the Law of the Sea Convention, stating, and this is just a summarized version of it, that they would not accept procedures for binding decisions on law enforcement activities. This is a reservation that they made. I'm not aware of any specific objections to it, but it is evident why they refer to it, because what the Russian Coast Guard was, of course, doing was law enforcement. This is what the Coast Guard does as NGOs in the safety zone around Priraslomnaya, and they act, and so it is law enforcement. Now, it is interesting to look at the rules that the Law of the Sea Convention itself has on reservations. It's very restrictive on reservations. So this is Articles 309 and 310. Reservations are not permitted unless they are expressly permitted. So the general rule is no reservations unless. This no reservations rule apparently comes from the fact that the Law of the Sea Convention it's a very long convention, 320 articles. It's a very intricate convention, deals with almost everything at sea. The feeling of the drafters at the time was that it was so much a package deal. If one state got what it wanted in one chapter, it would have to live with somebody else's view in another chapter. So it's a web of compromises. It was give and take, and in the end, the whole thing as a package is what we sign for. So reservations not allowed, except for a few reservations. And the few reservations that would be allowed concern disputes concerning marine scientific research or fisheries. Now that's interesting, because that demonstrates that the Russian reservation was perhaps a bit too wide. And at any rate, it implies that the Russian Federation cannot rely on its reservation to stop the jurisdiction of the Law of the Sea Tribunal. It's interesting if you read the decision. The decision itself is not that long. I think it's about 19 pages, so it's not a big burden to read it. It's interesting that if you read it, the court doesn't specifically say something about the reservation is not valid, but they are ignoring the reservation. So the reservation does not stop the jurisdiction. Okay, well, so we do our work. We go to Hamburg. There is plenty of journalists there. We explain to the court what's gone wrong. And we've explained that we really regret that the Russian Federation isn't there. We clarify a number of substantive legal issues to do with boarding of ships, to do with the arrest of ships, to do with the safety zone, etc. And then a little over 2 weeks later, there is a decision. This is a decision of last Friday, where the court basically gives the Netherlands everything it had asked for. the vessel and all persons detained in Russia are to be released and are allowed to leave the territory of the Russian Federation and the maritime zones of Russia, provided, and this is something that we had thought about, but not quite in such detail, provided that the Netherlands posts a bond of 3.6 million euro, and the other obligation is that we, both states, the Netherlands and Russia, report to the tribunal on the implementation of the decision by the 2nd of December, so that's next Monday. This is a majority decision, 19 against 2. As you may know, in international tribunals, unlike in a number of domestic systems, you get to know the way the voting worked. In the Netherlands, you'll just hear that this is the decision. In the Law of the Sea Tribunal, you'll hear that 19 of the judges voted in favor of these provisional measures, 2 dissented, and that's Judges Golitsyn and Kulik, respectively from the Russian Federation and Ukraine. Yes, I hear everybody laugh, but we thought 19 was really good, and 19 to 2 is, I think, is a good result. Mind you, we're not there yet. It's not ready. Initially, we thought, well, at last we can relax, but that's not the case. After the decision on provisional measures, of course, the arbitration continues. We have to continue establishing the arbitral tribunal, make sure an arbitrator on behalf of the Russian Federation is appointed, and then gradually the 3 others, and then we need to do the rules and all of that. That takes a little time. So the provisional measures part of the story is, as it were, it's just a bit that is taken out of the whole story. But now that that's been concluded, there is a decision by the Law of the Sea Tribunal, we continue with what we were doing originally, which is we return to the arbitration process. Of course, the other thing is that the way it has been formulated in the decision by the court, it says vessel and anyone on the ship is free to should be allowed to leave Russia and the maritime zones of the Russian Federation, provided that the Netherlands pays the 3.6 million bond. Now, a few things about that. The press has reported that it is a bond. Now, bond normally means that I give the money to you and you give it back to me, provided something happens. The way it's formulated, if you look closely at the text of the tribunal, is that the Netherlands is to provide a bond or other financial security. So the other financial security could be a bank guarantee. And the advantage of a bank guarantee is that we keep the money and we will guarantee that you get the money provided something happens. The reason, of course, for the thinking behind this, the interesting thing is, this is something that is fairly similar to the prompt release procedure, where the ship can go provided that a reasonable bond is set. And probably the tribunal has also been thinking about, well, in an arbitration, it might be that the other side also wants to bring a claim. The structure of this case is such that because we are there on our own, it's a case of one state against the other state, but we don't really hear the other state. We bring our claims, but it might be that if the arbitration returns to be an active arbitration, that the other state might also bring a claim. And we think that for that reason, the tribunal decided that a financial security was in order, and we are now, I think, looking at providing this because it is, under the terms of the decision by the tribunal, a condition for the release of ship and the crew. Now, briefly, something about the role of people. My mandate is to speak about the practice of international law, so I can talk a lot about what the law is like, but it is also, I think, in practice quite relevant the role of people. Court cases are not a mechanical thing. It's not arithmetic. Much depends on the people involved in a court case. Now, first of all, of course, we need to appoint this arbitrator in the arbitration. And arbitrator has not really been seen so far because he's not been working. Arbitration is basically on hold as long as we're dealing with the provisional measures. So the arbitrator, of course, is an important person. If you appoint your own arbitrator, you start looking for someone whose profile will fit the type of case that you're dealing with. You may want to think about, do you want a national to be an arbitrator? Certainly you want someone with good, broad knowledge of the law of the sea. They have to understand the subject matter. And it does help if they have had this role before. A novice arbitrator may not be such a great idea, but then at the same time, one only becomes an arbitrator by starting somewhere. Another interesting choice that we had to make was to do with the judge ad hoc. Now, the system in international law is that if you bring a case, or if you're involved in a court case, and you do not have a judge of your own nationality on the court, as is the case for the Netherlands, there's no Dutch judge in the court in Hamburg, you have the right to appoint a judge ad hoc. There is already a Russian judge, so the Russian Federation does not have that right because they already have a national on the tribunal. Now, this means you have to then also start thinking about who shall we choose? Here again, it's a question of, well, would you like to appoint a national? First question. Clearly, you need to appoint someone who knows what they're doing. But then it struck me that this is a very fast procedure. So the court is established. It's a group of 21 international judges elected every 3 years. 1/3 of the judges are elected every 3 years, and they sit for 9 years. So they have been working together on many occasions. They know each other. So there is this element of the internal dynamics of the court. Now, I could ask a very good law of the sea lawyer to join the court as our judge ad hoc, but if he doesn't know the court, he might be at a disadvantage. You have to have a sense of how do they do their work, how do they communicate, their internal style. In the end, that was for us an important reason to ask a former judge of the Law of the Sea Tribunal, David Anderson, who used to be the British judge on the court, to sit as our judge ad hoc, because we were convinced that he had experience on the court and that would help him fit into the current court and work with the other judges and participate to the maximum in the deliberations. I would say I think that has really worked quite well. Then there is an issue about the style and the role of agents and counsel. We made it a point to, and sometimes you get these arguments or these letters and you really feel very upset, to try and continue to be polite and to just be courteous and to keep saying that we are still open to discussions with the Russian Federation. That's the best tactics. We dearly love everybody, particularly our opponents. Never mind what we say about them behind closed doors. But it makes sense to in preparing your case, to raise that issue specifically. We're not at war. We have something which I think is a difference of opinion. And since we can't really sort it out ourselves, we've asked these wonderful judges to do that. Another element, and this is always an interesting point, the Law of the Sea Tribunal is bilingual. They work in French and English. And what you very often, this is the same thing for the International Court of Justice, they work in English and in French. Even if we know that all the judges will understand English, the whole session is also interpreted. So you pick up your earphones and you can hear what is being said in French. We thought at one point that we would not be doing any French. And then in the end, yes, we did. I did half of my statement in French. Not because I think that anyone understood it any better when I did it in French, but because you need to make sure that you use all the possibilities to draw in all the judges. You want not just you want them to listen to what you're saying, but you also want to get their sympathy. And for Francophone judges, and of course there are Francophone judges on the court, it really helps if you, if you make use of French, and they would see it as a courtesy. And to my surprise, after the oral hearing, I ran into the Lebanese and French judge, who immediately started about the fact that they so much appreciated that I spoke French. So these are simple things, but it makes a difference. And they also started to say immediately, well, in a recent case, they only spoke English, and it's, we work in 2 languages. So, okay, well, right, I just made the point. And then in terms of the role of people, of course, this is an unusual case in terms of it is a ship under Dutch flag. That is our title for acting, but it is a Greenpeace ship, and they have many relations here, there, and everywhere. So it took quite a lot of investment in terms of time and patience to work with Greenpeace, because at times it's maybe not a great idea to, I don't know, hang in the trees in the park where the tribunal is hosted. So it is relation management in the sense of, well, we do need you for some elements of the court case, and yes, if the ship is released, that's going to be to the benefit of the state, because we're the flag state, and obviously it's also going to be to the benefit of Greenpeace. But at the same time, you don't want them to do typical Greenpeace things, because that might just not be very helpful. So managing that relationship, I thought, was an interesting challenge, if I can put it like that. Right. I think that's what I wanted to say at the moment, but I wouldn't be surprised if there are any questions.